With respect to treaties, I have to just respond on one point. The reason that the administration was able to submit so many or exchange so many instruments of ratification in 2009 was that in 2007 and 2008, we had actually pushed through more treaties through the Senate than at any point in American history. 90 treaties in 2007, 2008. I happen to know that because I testified in favor of a number of them. But the difficulty is that in an election year, it's going to be very difficult to get any of these treaties through, certainly any of the major ones that I know that you and I have been concerned about. So my question for you is, given these difficulties for the legal advisor, who is in fact hemmed in by the rest of the administration, by the Senate, by domestic politics, how are you addressing these difficulties, and what progress do you think you will make on some of these issues going forward, particularly in this year, an election year of the United States?
I think we can... I think we can address these from our seats here. So there should be a button there for you to hit to turn on your microphone.
Well, let me, I acknowledge John's focus as legal advisor. Many of our goals were the same. I think we're pointing to three different factors. One, there were areas in which the Bush administration reversed itself midstream, made errors, grievous errors early, through the hard work of people like John, got those policies either stalled or stopped, and started trying to move the pendulum in the opposite direction. And I have no problem in a continuity of policy with things that already recognized that earlier things were a mistake. There's a second area, which is areas in which progress has not been possible because it's not the executive branch acting alone. This is a group of people who lives in Washington. Every single one of you has focused on one or more issues in the political environment in which we're living, which make it very difficult to get things done through legislative process, regular legislative process, much less treaty process. John said the ICJ requires a legislative solution. I agree. That explains why it has not been possible to get that problem solved. Now, you could take another approach, which is to say it doesn't involve a legislative solution. The risk you run there is you could have a non-legislative solution to the ICJ problem that's legally ineffective, or which is struck down by the Supreme Court. And I don't think that we advance the interests of the ICJ to pursue a policy at, using the capital that we have internally to achieve a result which doesn't end up actually implementing our obligations under the treaty. Now, I give John and Secretary Rice great credit for their efforts to try to implement the Avena judgment through non-legislative means. It turned out that the Supreme Court, in a decision that I think was incorrect and found surprising, didn't buy into that. So, the second time, we have to be even more careful about how to do it. So I won't go into the details of the things that we're exploring on this, but I think the statement that we're doing nothing is simply an acknowledgement that until we have the approach that's going to work, I think we need to take our time. But I think that the third area to be pointed to, I pointed to areas in which legislative inertia makes it difficult to get the change as quickly as we'd like, in areas in which there has already been a significant shift of policy where we're keeping the pendulum moving. I do think that there are significant areas of change. I think on human rights policy, re-engagement with the Human Rights Council, I think the process I think that John helped to move the relationship with the ICC from hostility to some sort of benign coexistence. Or I think the term that John uses, we accept the reality of the court. This did not involve attending the Assembly of State Parties meeting. It didn't involve engaging with the aggression issues at Kampala. Those are steps that we are moving toward. I think that a formal statement of recommitment to the Geneva Conventions is something that we have done. We're taking different approaches in a number of the domestic litigation cases, salmon tar being one of them. We have re-engaged on climate change. Our military issues are connected to the President's decisions with regard to withdrawal from Iraq and a new strategy toward Afghanistan. I think our attitude toward the United Nations has changed. As you may have noticed, John Bolton is not our ambassador to the United Nations. On detainee policy, I've enumerated the numerous areas of change. The Military Commissions Act have been amended and reformed and have at this point been designated for a small number of cases. I disagree that the rendition policy is the same. We have had a detailed interrogation and transfer report, which has set the terms by which transfers are being done. And we are still in a situation in which we are in armed conflicts. Our goal is that armed conflicts should occur within the framework of the law of war. I think the fundamental difference between the approach that we're taking and that of other administrations is that we have a view of domestic law in which we're relying on the authorization of the use of military force resolution as the basis for domestic authority, and on international level, we're operating within the framework of the laws of war. That doesn't mean that we're not still engaged in military actions, that we're not still engaged in defensive exercises. We are in serious conflicts. Those require vigorous exercise of those lawful tools that are available to us, and that's what we're making use of. So I think that a nuanced response to your question, John, is in the areas where you started to do the right thing, we're continuous. In the areas where both you and I would have liked for Congress to be more forthcoming, we're encountering the same obstacles. In those areas where we have discretion to modify and move the policy, we're moving it.